All rise. The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Welcome to this session of the Iowa Supreme Court held at the campus of the University of Iowa Law School. We have one case scheduled for argument this morning. That case is State of Iowa versus Smith. And Ms. Nye, you may proceed.
Good morning. May it please the court. My name is Melinda Nye, and I represent Trent Smith, the defendant applicant in this appeal. Trent and Mary have a child together. They were in a relationship, but as of June 2013 had broken up, or not living together, but they shared some sort of custody with the child and visited her. On June 9th, Mary called the police. Police were dispatched to her house and found her sitting in her car with their daughter and her dog. And when they questioned her, she told them that she had been inside the house sleeping. This was about 1 o'clock in the morning. She'd been sleeping, went upstairs, woke up, went upstairs for something. When she came down, she heard a noise, and someone broke into her house and assaulted her. She didn't know who did it. And police were a little skeptical of her story and pressed her, and after about half an hour or more of questioning, she told them that Trent Smith was the person who had assaulted her that night. She was concerned about having a broken arm, thought that her teeth might be loose. She said she'd been knocked to the floor and kicked and hit. And so the police took her to the emergency room where she talked to emergency room personnel. She first spoke with a nurse who asked her what had happened, and she said, "My baby's daddy assaulted me about midnight." A little bit later, the nurse asked her some screening questions where she indicated that she didn't feel safe at her home, that someone close to her had hurt her, and that she felt someone was taking advantage of her.
So why isn't that admissible under one of our exceptions to the hearsay rule? And in particular, the nurse, I think, testified, correct me if I'm wrong, but the nurse testified that her inquiries were pursuant to a hospital policy, and indeed the AMA has a policy statement suggesting that these kind of screenings for domestic abuse should occur as part of the care and treatment. So why doesn't the statement to the nurse come in under the exception of the hearsay rule?
So there's two pieces to that. First, the state argued that it fell under the exception for statements for the purpose of medical treatment and diagnosis. And traditionally that exception to the hearsay rule does not include statements of fault or statements identifying, in this case, an assailant.
Well, but isn't the criteria what we established in our case law? It's a two-pronged test. Isn't the real question whether the information was reasonably necessary for the diagnosis and treatment? And in some occasions, an individual identification might be.
Certainly. That was Renville, and then the test was adopted in Tracy.
Yeah.
And so the two-pronged test that we want to ensure that the patient's motives in making this sort of identification, that they've held that it can be admissible, particularly with a child.
Do you have any problem with motive in this case, the first prong?
It's not. The important thing in Renville, it was important in Renville, and Tracy noted it when the court approved of the Renville test, was that the doctor in that case had advised the child that of the importance of being truthful and forthcoming, and said, this exam and my questions are about your treatment, and if you tell me the truth and you're honest, I can help you get better, I can treat you, and explain the nexus between the identification of her abuser and the treatment and the diagnosis and treatment that she would receive. Secondly, so in this case, there's no such advisement. There's no evidence in the record that she was advised about it.
I think that's right, but the first prong in Tracy is not all that demanding.
Right.
I mean, it just says the motive has to be consistent with.
You know, I'm not sure Tracy specifically acknowledged the advisement. It referred specifically to the fact that this patient was advised of the need to be honest. And so I don't think it's quite as broad as anything that gets said in a doctor's office is admissible because
Isn't it
you're
kind
there
of
for
obvious
treatment.
in an emergency room in which and you're being interviewed by staff that it's related to diagnosis and treatment? I mean, you're not here for education. You're not here for...
Not necessarily. We've got, in this case, she had already called the police. She was escorted to the hospital by police. So she'd started sort of criminal proceedings or some sort of criminal complaint, which she later, of course, tried to withdraw, which is why we're here. But that wasn't, you know, she's very...
Didn't the nurse testify in effect that the identity of who assaulted her was reasonably related to diagnosis or treatment? And if so, isn't that enough?
I don't think the nurse did testify. I wouldn't agree that that was characterization. She said we asked these questions of everybody. We're referring only to the screening questions. We asked them of everyone. She testified that when Mary said, "My baby's daddy assaulted me," made that statement, it was in response, as far as I could tell, it was in response to the question, what happened?
Oh.
Sort of a very general, why are you here?
That was the doctor, but what about the nurse?
That's what the nurse said too.
Well, but I think the doctor said that asking these types of questions are simply key to their diagnosis and treatment.
You know,
I think is Dr. Mott's testimony.
He testified that finding out what happened is key. And I think that's different than this very specific issue about identification.
But her response was just that. What happened? And then her response is, "My baby's daddy beat me up," or something to that effect.
And I think his question, all the state needed to do was ask another question. The state has the burden of establishing the foundation here. And they didn't ask questions to establish that ID, knowing that generally that identification and fault are not part of...
But there wasn't an objection raised on foundation, right? So what the defense lawyer should have done, right, is if the defense lawyer thought the foundation was inadequate, was ask permission of voir dire the witness outside the presence of the jury, right?
Possibly, sir. But
Well,
we still have to rely on the record we have to make
in a business records context, though, don't we expect the proponent of the evidence to lay the foundation?
Certainly.
And in this case, so I take it your argument is in this case that wasn't done.
There wasn't a foundation. It was argued about. It was discussed in limine. It was objected to every time a piece of that, whether it was the records or the statements from the nurse, it was objected to. And the court had already said, I find it admissible. And so whether other further objection would have been necessary.
What's missing from this record so that it falls short of establishing the medical treatment exception?
I'm sorry,
What foundation is lacking on this record, given the testimony of the doctor and nurse?
Given the testimony of the doctor and nurse, so what's missing is some testimony from the doctor, because I don't believe that just saying what happened is key. I think that's too broad. That refers to being assaulted or falling downstairs or what happened. Some testimony from the doctor that finding out the identity of that this was a domestic violence situation was relevant to her care, establishing that we need some expert testimony that there's a nexus there. And in all these other cases the Court of Appeals cited where they've allowed that testimony was there. There was express testimony from the doctor.
That's my concern. You know, the doctor could say what he wants or she wants, the nurse could say what he or she wants. But they can't decide whether it's admissible by saying magic words. I mean, don't you need for those people to say why it is necessary for the treatment? And these other cases you read, you see, well, like in the juvenile case, they have the authority to have the person removed from the home. They don't have the authority to remove an adult from the home. So why and maybe you answered it, but the bare statements alone, you don't think can get around the rule of evidence?
Not the bare statements here. We need some other expert testimony that explains whether that doctor can give it or somebody else needs to give it, that explains the nexus and that the standard of care includes treating the psychological injuries, that puts a duty on the doctor to treat the unique injuries, that there are unique injuries relevant not to any assault but to a domestic assault.
In a lot of these cases we have, it's implied. We just have the implicit finding of the district court in this particular case, as opposed to the explicit finding that you're looking for here, which we don't have. And several of our cases then say that we can go ahead and rely, even though the record's not complete, in many of these cases the record isn't as complete as we may like to have it, but by implication we can see that there is a proper foundation.
I assume you're talking about the children victims of sex
I
abuse?
think it can be either one. I know we're talking about extending it from more of the children's context to an adult situation like this, but oftentimes the record is pretty inadequate to really do a thorough analysis of it, and so many of the cases talk about simply implying that foundation there and letting us or the jury or look at it and make their own implicit findings.
Well, that might be true with a child, specifically for the reason that Justice Wiggins was discussing, that it's maybe more appropriate to imply or assume that there's a medical duty that is part of care and diagnosis when you're dealing with a child, because there's a legal obligation on doctors to remove a child from an abusive situation or to ensure the child's not returned.
But isn't the standard whether or not it's necessary for diagnosis or treatment? Well, the duty to report, it isn't related to diagnosis or treatment. That's a separate statutory obligation. So in Runville, we've held that when a child is involved, it falls within the necessary for treatment or diagnosis. And on that standard, why wouldn't we extend it to domestic abuse involving another family member that's in an environment of assault?
I think part of the Renville holding was there's a psychological component, but it was heavily influenced by the fact that in that unique situation, it was part of the medical standard of care to find out that identity and prevent it
just
from
like a
happening.
child, the dynamics of domestic abuse tell us that the power and control and the difficulty, or if not the impossibility of finding a way to get out of the situation and get out of the relationship. So aren't we dealing with very compatible concepts?
There's some similarities, but I don't think they're identical. We've got a child who cannot, is sort of helpless, is stuck in their situation, doesn't have the legal ability to remove him or herself. In domestic violence, we're still dealing with adults who make their own decisions, whether we like them or not. Not every case that's charged as a domestic abuse assault involves this sort of extreme power imbalance and cycles of abuse.
But that's certainly documented in the literature and the research that component exists.
It can, certainly, in cases that, but any two people who live together or share a child who get in a dispute will be charged as a domestic abuse assault, but that doesn't mean that every one of those cases involves that cycle of abuse.
In this case, does the record? I'm a little bit confused about whether the defendant Smith was living with Ms. Dean. Were they actually cohabiting, or
No.
Does the record show that?
There's in
clarity?
They were not in my end. I'll find the exact testimony if it's there, but it's also in the medical records that she was living. She refers to it as her house, and that she said that they weren't living. She talks to the police. She says the police don't like Trent because in the past there had been something else, and he'd been at my house. So there's reference that they don't live together any longer.
In this context, then, should it make a difference to the court whether they were actually cohabiting, residing together, or not?
This is where we need medical expert testimony to explain to us whether that matters. I can't tell you if that matters. I mean, certainly I can make up a hypothetical that someone who still has a cycle of abuse and sort of is in this, you know,
Well, I
horrible pattern, but I can make up one where it's just a...
I think the record reflects that they were not living together. It was her house, but then you had the testimony of the child, or at least the evidence from the child, is that he was, and it wasn't done on a matter of the cohabitation. It was actually done on the fact that they were parents of the same child, which is a totally different standard than whether they're cohabitating. But you did have, I think, evidence from the child that said, Daddy comes over all the time, and he's living there. And had inconsistent testimony about whether he had the code to the security system or a key, or, you know, so there's a lot of disputed evidence there.
Yeah.
Just for clarification.
Let me ask this question. In a personal injury case, it's standard for somebody to say, I had a car accident on, you know, they tell the doctor I had a car accident on this day, I had pain afterwards, blah, 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 blah. It's never objected to, and it's standard. So how does this differ from the typical personal injury case, where the doctor is always told how the accident happened?
You're saying that they're able to identify it was Mrs. Robinson driving the green car
Yeah.
that crashed into me?
All the time.
My understanding is that that shouldn't be, that should be objected to, that sort of fault identification is not that you would need to establish that it was important to the doctor that was relevant to their treatment to get that piece of it. And he could say, I was hit by a car, but not that it was a green car and who was driving it and they ran a red light, and that wouldn't come in under this exception.
Chief, could I ask one more question? Ms. Nye, here's what I'm focusing on. Page 54 of the appendix, and this is where the nurse is asked, as a nurse, do you ever ask people with regard to domestic violence situations questions specific to their situation? The answer is yes. We have screening questions we ask every patient, suicidal or homicidal, and they answer yes or no. If they feel safe where they live, any domestic violence going on, and she answered yes to that. That seems to me to establish that this is a legitimate inquiry for purposes of medical diagnosis and treatment. Why am I wrong?
It could be. Again, the problem is the record doesn't indicate that they treated her.
Well, the question doesn't call for the identity of person. It calls for the question of whether there's domestic violence in the house. The answer could be yes or no. The real question, it seems to me, is whether the specific identification that the daddy was doing is relevant for medical diagnosis and treatment. Or would it have been adequate to say generically what the problem was?
Well, and when you look at the records, there's this, they quote her statement, my baby's daddy did this, but everywhere where they talk about a diagnosis or a complaint, it's simply assault. Because it's assault, there's no indication she received any sort of
But does the rule,
treatment.
let me ask this though, we're extending time a little bit, but does the rule require, in order to qualify for the exception, does it require that the information actually be used, or only that it's kind of objectively, reasonably could have been used?
I think it needs to be used. It needs to be, because that goes again to the patient's motivation in saying, in telling the doctor, making the statements of identification or fault. And this is already the exception for these medical statements. It's already an exception. Generally, we don't let hearsay in. The rule starts with you don't get it in. And then there's specific policy reasons that they allow this exception. And so now an exception to the exception is kept narrow, and it doesn't just mean, again, everything that somebody says in the doctor's office comes in.
Thank you, Counsel. Mr. Bueller.
May it please the court. Like many victims of domestic violence, Mary was afraid. She was afraid and reluctant to tell the police that her boyfriend had beaten her, kicked her, and called her a dirty whore. She was afraid to tell anyone what happened. By the time trial came around, she said that her injuries were caused by a trampoline. This case is the embodiment of the cycle of violence that we see in domestic abuse.
Well, what the case is really about is the two-pronged test in Tracy, I think. I mean, the rule that we announced here doesn't apply simply in domestic violence cases, although it does, but it will probably apply in any assault case where there's also, or at least some evidence of psychological injury. So we have a two-pronged test in Tracy, which, as I understand the briefing, I mean, frankly, it's kind of embraced. I mean, both parties kind of say, both parties recognize, of course, there's a general exception to the hearsay rule, and then Tracy has A and B. And frankly, I'm not so sure the fact this is a domestic assault is all that significant. The real question is, do you satisfy, number one, is the motive, I think, consistent? And number two, was it such as reasonably used in medical diagnosis? I'd like to focus on the second issue, and that is, why do you need to know the identification of the person? I mean, arguably, one could say, well, you need to know something about causation. But why do you have to know it's actually Mr. X in order to provide medical diagnosis and treatment?
In answering that question, you asked where in the record does it establish that fact was needed to treat this person at this time too?
Remind me if I don't get there as I'm addressing Justice Apple. The reason that this information is necessary is because it's a domestic violence case. This is different from the sort of assault we see on the street where someone walks up and slugs someone else, and the reason is that cycle of violence. And we do have some of that evidence in this record from Barbara Rendell's. That's at 264 to 274 in the transcript. Doctors don't only treat the injuries you can see. If you walk in with a broken arm, they treat that. But there's psychological damage with many, perhaps all victims of domestic violence, and that's what these questions go for.
But not only victims of domestic violence. I mean, one of the problems I'm having is the scope of this rule, and I tend to agree generally with the proposition that throughout our common law history and so forth, hearsay has been looked at skeptically, and our rules basically embrace that notion with certain exceptions. My concern is that if you prevail, the hearsay exception is really going to get swallowed up, and that in any assault, any willful injury case, there is going to be some psychological or emotional issue, I take it. And does the rule really contemplate triggering individuals, or does it contemplate the mechanism of the injury?
The identity of the individual is relevant, particularly in this context. I know there have been some questions about whether Mary and the defendant were living together, and I'm not sure that's quite the reason that this information would be relevant. The reason it's relevant is he has access. They have a child together. He sees her a number of different times during the week, and that facilitates this cycle of violence.
Well, what can the doctor do to avoid the access? I mean, in a juvenile case, the doctor could call child services and have the child removed from the house, and the access is done. Tell me what a doctor, physician, or hospital or healthcare provider could have done in this case to deny them access from each other.
That's not what doctors do, Your Honor, and I'm not sure that's why this information is admissible in Tracy. It's not because the doctor has a statutory duty to report or anything like that. It's for treatment.
I'm not talking about a statutory duty, but in a juvenile, he can treat the symptoms of violence and the future psychological harm by removing the kid. I mean, you can do that. It's just like if you're got poison, you're taking a slow poison in a physical injury, the doctor takes the poison away and you start to heal. But how can the doctor do that when two adults are involved? And tell me specifically, and maybe I'll go back to my question, what did the doctor do in this case in treating or diagnosing that required the name of the perpetrator?
He prescribed psychological medication. He prescribed anti-anxiety medicines.
But why do you have to know the perpetrator? Tell me what, based on the perpetrator's name, that caused him to do anything different.
It's very different if the person that you have a child with is abusing you versus a stranger on the street. There are very different psychological consequences. We know this about domestic violence. We know this is a cycle of violence, abuse, and control. If a stranger had walked up and attacked the victim on the street, sure, she'd be upset. She might need anti-anxiety medicine at the time she's at the hospital. But she was also prescribed anti-anxiety medicine for when she went home, because this is a persistent, ongoing problem.
Counsel, I understand that, but in this instance, I think the patient was already on anti-anxiety medication before this incident. Should that make a difference?
No, Your Honor. The record isn't entirely clear on what medicines and what effect they had. We have the medical record, sure, but nobody really testified that she was on this before the attack, and that's different from what she was on after the attack. What we do know is she was prescribed anti-anxiety medicine for her stay at the hospital, and she was given a new prescription for after her release. And that helps treat the psychological harm that flows from domestic violence.
I have one other question that relates to the text of the rule. And so my question is, why shouldn't our analysis here be really strongly informed by the language of 8034, in particular, the language that refers to describing the inception or general character of the cause or external source? Shouldn't that language inform our decision in the sense that what the rule really focuses on is the general nature of the cause or the external source? So in other words, the doctor clearly would be interested in knowing whether the injury that is being reported by the patient was a blunt force trauma, whether she was kicked or punched, but not the identity of the person who perpetrated the assault.
I do think it's important to look at the text of the rule, and it's also important to recognize in that text we're not only talking about treatment, but also about diagnosis. For your hypothetical question about source of the injury, blunt force trauma, sharp force, whatever it might be, sure, that's relevant and maybe enough if all we were talking about are physical injuries, but we're talking about a lot more than that. Doctors today believe in whole patient care, providing psychological counseling if necessary, providing medication for psychological injuries, and you need to know the identity of the defendant to assess that situation.
Counsel, this is a recurring problem where the domestic abuse victim names the perpetrator in the ER and then later doesn't want to cooperate with the prosecution. Should we take these cases one at a time, case by case, or is this case a good vehicle to adopt a categorical rule the Court of Appeals stopped short of using? We've got the legislative factual record from the AMA guidelines. We know doctors routinely do domestic abuse screening in the ER when they see trauma. Why not just hold the identity of the victim comes in under this hearsay exemption?
That, in the state's view, is the easiest way to resolve this case. The Court of Appeals does stop short of there, and is an intermediate appellate court. It's easy to see why they might choose to do that.
Well, maybe because they wanted to rely on reliability as the focal point of the analysis, not some external public policy. We have sometimes had cases where external public policy arguably distorts the evidence rules. The real issue here, it seems to me, is one of reliability, and that's what Tracy's all about. That's what Renville is all about. And make your pitch, if you want, for the categorical rule based on the reliability aspect of the case.
I think it's exactly what Justice Waterman already identified. We know so much about domestic violence today that it's so telling that the only decision the Court of Appeals cited adverse to the state's position is from 1978 in Alaska. Our understanding today is so different from 40 years ago.
Yeah, I've read those cases, and most of them are fact specific. I mean, they apply. I think the two prongs in Tracy and Renville are fairly common.
Yes.
They're stated somewhat differently, but they're repeat actors. And ordinarily, in the cases that I saw, and please correct me if I'm wrong and alert me, but ordinarily the two prongs are projected against a specific factual scenario.
I think that's mostly right. We see a little bit around the edges. There's some, one court will rely more on the facts, one will rely more on these public policy things, the AMA guidelines, for example. I think the reason a categorical rule is probably the right solution is that anytime a doctor's asking a question, it's because the doctor thinks that it's medically necessary and pertinent. And we don't need to look any further than to see what was charted here. Nurses and doctors don't chart irrelevant information, and we see in the chart the identity of the perpetrator. Nurse Nipper testifies that this is institutionalized at the hospital. It is so relevant, and to Justice Waterman's point, so common that we ask every single assault victim to come into the ER these questions.
Could we decide this case, what was said to the doctor and nurse, under the excited utterance exception? I mean, the Court of Appeals held it was inadmissible as to the police because they repeated the question. It took them a while to get the name out of her, but she volunteered it right away in the ER.
I think we could see that admitted under Rule 803-2. Mary was still very upset when she got to the hospital. She was so upset that the doctor, Dr. Mott, describes her as extremely distressed. He prescribed anti-anxiety medicine right then. And we know that she arrived at the hospital around 2 o'clock, somewhere around there. The record's not exactly precise. The assault happened somewhere around 1 o'clock. That's certainly not outside the realm of an excited utterance. And if you look at the dash cam in this case, you see just how upset this woman is. The police officers at one point on the tape around 2 o'clock describe her as scared shitless. That is a very telling description. She is so afraid to tell the police what happened. You hear her voice quivering. She yells at them, "You can't protect me forever." This is a woman trapped in that cycle of violence. She is very upset. She is terrified to tell anyone what happened. And she does this entire conversation with a 5-year-old just feet away. So is she screaming every single second? No, she's trying to put on a brave face for her child who was home when this horrific attack happened. And the last consideration under 803-2 under the 4-prong test is the nature of the event that led to this excited utterance. And this assault was horrific. She was beaten, she was kicked, she was thrown to the ground, she was called a dirty whore, and she was kicked in the face to the point where she blacked out. This qualifies as an excited utterance. From the moment the event happened through the statements that she made at the hospital, there's no evidence that she calmed down. And even if she had, this court said in Mateer that when a witness is calming down, statements related to the inception of that exciting event are still admissible.
I want to go back to an earlier point you made. You said that she was given this drug when she left because of her anxiety, but if you look at the record on page 211, she came in taking 0.5 milligrams of Xanax, and that's the same prescription they gave her going out on page 231. So they didn't change her anxiety medication.
No, I don't.
She has a history of anxiety, so, you know, were they treating the anxiety she came in with beforehand, or was she treating the anxiety from this incident when they kept the anxiety medicine at the same length, at the same thing, and just gave her a prescription?
I don't think we have to do any guesswork to know that this was a psychologically traumatizing event. She was certainly more anxious after this event.
But isn't every assault a psychologically traumatizing event? I mean, if you're walking in downtown Iowa City, if someone comes out and beats you up, I'd be psychologically traumatized. Maybe you won't, but I would.
And let's say that she didn't give up the daddy, that she did. But let's say, what difference would that have made in the treatment?
It would have been relevant to know
what difference would it have made in the treatment?
They might not have prescribed the anti-anxiety medicine. If they had known that she was leaving, they might not have renewed her prescription. She was given a new prescription. We don't know when the old one would have lapsed. That's an unknowable.
But why did they say that? They were giving it because of the continuing domestic abuse. So why didn't someone, county attorney, get that in the record?
Because we don't plant words in witnesses' mouths. That's not how doctors would think, is the exact cause of this is the domestic violence. What they would think is that based on the history I've received from this patient, there's an ongoing anxiety problem. Part of that is caused by the events that led her to come to the ER that night, an assault by her baby's dad.
We try cases. I don't know, how many have you tried?
7, I think, at this point.
Yeah, and when you try these cases dealing with personal injury and physical injuries, you always ask the doctor, why did you give this drug? For what purpose? That wasn't in this record. Why did you give the Xanax? I mean, those are questions I think you have to do to get to the factual basis. And I don't disagree with you that if you meet the 2 requirements of Tracy, it comes in. But my problem is I don't see where the county attorney made the record in this case, showing that it was necessary for the treatment. Now you're hypothesizing, well, the anxiety, and you're hypothesizing, well, it's domestic abuse, and we can read the literature. No doctor said that. I mean, and those are the things. And the question then becomes the questions that the nurse asked, and I think Justice Mansfield brought up the point, is that because the hospital needs to know to protect itself from liability, or is that because they needed to treat the physician? And that's another question that was never answered. So that's what's bothering me about it. And where in the record does it show it was needed for treatment, not just us assuming it was?
With the Chief's permission, I'll go ahead and respond. I don't think that information needs to be in the record, and it's not laid out in that exact question format that you're suggesting. We can draw inferences from what we know about domestic violence, from what Barbara Reynolds testified. And it's important to remember that this is a 104A question. The state doesn't have to prove beyond a reasonable doubt that this is admissible testimony. 104A talks about evidence sufficient to support a finding. We have that here from the testimony of Nurse Nipper that asks every question this because it's part of the screening. We have it from Dr. Mock, who says that this information is key. There is evidence sufficient to support a finding under Rule 8034, and I'd ask this court to affirm the conviction.
Thank you, counsel. Rebuttal argument?
Try to be quick. I would note that while there's some discrepancy in the testimony about her level of anxiety, the doctor testified that she was anxious and that he prescribed this to help calm her down, and that she was reporting incredibly high levels of pain that weren't matching up with her injuries. And actually the prescription he gave her in the ER was not right away. It was after at least an hour or two, and she wasn't getting relief from pain. And he prescribed it for her pain. He didn't actually even prescribe it for her anxiety. He just noted the relationship sometimes between anxiety and pain.
Was that the fentanyl, or was that the oxycodone, or was that the
lorazepam.
Okay.
Yeah.
Could
That
you
was
address
the-
whether what she told the nurse and doctor to identify her assailant is admissible under the excited utterance exception to the hearsay rule?
I think, given the circumstances that this is several hours, she reported she was attacked at midnight, calls the police at 1, gets to the hospital about 2:30 or 2:40. She's had time. Part of the rationale for the excited utterance is that certainly, you can argue she was excited or anxious, but it has to be made while there's sufficient indicia that there's not time to reflect and make up stories and tell a lie, essentially that we're going to trust it. And the whole argument, the whole discussion with police is their argument, the state's argument is she's lying to us until eventually she tells us the truth. And so clearly there's enough time, and she has the wherewithal to be making up stories because she changes her story several times. And so I don't think it falls under excited utterance. I think her earlier statements, she can't sort of renew an excited utterance after she makes some that aren't, and then 3 hours later gets excited again about something that happened before.
I wanted to go back, I guess, to the medical treatment component of things. We know that the state has the burden of showing this. Is there really anything in the record that provides an adequate foundation or any type of fact-finding that this is credible or that it's really reasonably necessary for medical diagnosis or treatment?
There's not in this record. This is, talked about maybe adopting a categorical rule, and this, even if the court were to entertain that, this is not the case to do it, because we're relying on these sort of general feelings and general layperson's knowledge of domestic violence, and just because of...
So, is it your position, I just want to understand, is it your position that when a woman arrives at an emergency room, victim of physical violence, in emotional and mental distress, it is not pertinent to her diagnosis whether she's a victim of domestic abuse or being beat up by a stranger?
I don't think there's a categorical... I don't think I could say it will never, ever be relevant. We need that medical testimony. We need to hear from an expert about why it's relevant. It's not
We
something...
normally require expert testimony in order to apply hearsay rule exceptions.
When you're talking about an exception that's to a medical provider, and the question is it medically relevant to treatment and diagnosis? Who else can answer that question besides a doctor?
Well, what do you make of the fact that there was no fact-finding here? I understand there was an order entered denying exclusion, but there was no fact-finding under prongs 1 or 2 of Tracy, if I understand it correctly. Does that mean there's a remand to have the district court, based on the record, do the appropriate fact-finding on prong 1 and prong 2?
That would be something. That would be certainly, we'd rather have a whole new trial, but yeah, that's if the court doesn't think there's a record. But really, I mean, the state had their chance to make the record, but without, there's just not enough there to make that determination on this record at the appellate level. So somehow we got to get there. I also don't think, I think with that, I'll conclude unless there's further questions. For the reasons I've argued and in my brief as well, we ask that this court reverse that portion of the Court of Appeals, or vacate that portion of the Court of Appeals decision and remand for a new trial. Thank you.
Thank you as well, Ms. Nye. That concludes the case of State versus Trent Smith.